Mr. Thompson, I was going to ask you if you could try to keep your voice up.
Certainly.
As some of the members of the bench were having some difficulty. And we have a packed house this afternoon, so there'll be people at the back who might like to listen to the intricacies of our tax law as well.
Certainly, Lord. Well, to pick up on the submissions I made just before lunch, I wanted just to indicate to the court what the structure of my remaining submissions would be. There will be 4 chapters to what I have to say this afternoon. The first will be some overarching headline points. There will be some degree of repetition in what I said just before lunch in that chapter. The second chapter will address the appellant's construction of paragraph 13.4 of Schedule 10. The third chapter will be concerned with the construction of paragraph 13.4 for which I contend on behalf of the Commissioners. And then fourthly and finally, I will address the issue about whether there are sufficient findings in fact to allow the appeal depending on the construction the court arrives at of the relevant provisions. Turning then to the headline points, the first point is this in my submission. In any appeal, of course, it's incumbent on the appellant to persuade the appellate court that the court below has gone wrong in law, and in my submission on analysis, the appellant has failed to identify a sound basis for the allowance of his appeal. In my submission, his construction of the provisions is not correct, but even if it is correct, he does not have the necessary findings in fact to allow the appeal on the basis of that construction. The second headline point is that the statutory purpose of the anti-avoidance provisions in paragraphs 12 to 17 in my submission is of material importance for the purposes of the question of construction which arises. There are 4 particular points I would mention in that connection. The first is that which has been mentioned already and which is common ground, that the essential purpose of these provisions is to preserve the basic principle that an exempt business should bear tax on supplies made to it by being denied the opportunity to treat that tax as allowable input tax, giving rise to a credit, a VAT credit. Secondly, and following on from that purpose, the basic principle may be applied in any given case to prevent the exempt business which has a requirement to incur capital expenditure in relation to a property, to prevent that business from using the option to tax to create schemes which either have the effect of reducing the VAT payable by them or which allow them to defer the payment of VAT. It is the third point in this connection is it is the existence of the capital item or the expectation or intention that there will be one that is key to this provision for the reasons to which I'll come in due course. The third headline point is that having regard to the statutory purpose and the language of the provisions enacted to give effect to that purpose, the appellant's construction is not, in my submission, consistent either with the purpose or with the language of those provisions. There are 2 principal points to note in that respect. The first is that, at least on the basis set out in the appellant's written case, according to him, on a proper construction of paragraph 13.4, the option to tax will be disapplied in every case where there is a sale of property which is exempt land, where the seller has opted to tax, and where the sale price is in excess of £250,000. That's the way he puts it, for example, at paragraph 7.14 of his written case, pages 69 to 70 of his case. And that's why he says in his written case and in his submissions that proof of those objective facts, as it was put earlier in argument A, B and C, that's enough, according to the taxpayer, to give rise to the disapplication of the option to tax. So in other words, the option...
Subject to the timing point.
Subject to the timing point, although the timing point is more directly relevant in relation to the question of whether the land is a capital item rather than whether it would become a capital item. So in other words, the option to tax is disapplied in all arm's length sales of exempt land where the price is more than £250,000. My submission is that that must be wrong. In a purposive construction of the provisions, it would amount to an unjustified interference with such transactions, and it certainly doesn't serve the purpose of the provisions to render such transactions exempt sales or exempt supplies. The second principal reason in my submission why his construction is not consistent either with the purpose or the language of the provisions is that he appears to characterise the necessary intention or expectation as being a deemed or assumed intention or expectation that is deemed or assumed to arise in every case where there is a sale of exempt land for more than £250,000. That's not in any way in my submission consistent with the language of the provision. Even on his construction, and this is the fourth headline point, my submission is his appeal must fail for the want of findings in fact, and I'll explain in due course why that is so. The fifth headline in relation to construction arises in the following way. My submission is that paragraph 13.4, construed purposively, was not intended to apply to the transaction in this case when the provisions are viewed realistically. And I have in mind the well-known principle of construction that's referred to in my case at paragraph 47, referring in due course to Lord Briggs's judgment in Balhousey at paragraph 24. To resolve the question of whether these provisions were intended, viewed realistically, to apply to this transaction, my submission is this, that properly construed, the better approach is to recognise that a taxpayer could not have, and thus the appellant necessarily did not have, the requisite intention or expectation as to the creation of a capital item arising in the hands of the grantee, CSPV, in relation to the acquisition costs associated with the grant itself. And as I'll go on to explain, that is because that takes one in to the type of exercise which arose in some of the questions which my Lord Sales put to my learned friend about how the expectations subjectively could arise and how it could ever be understood that there could be a subjective intention or expectation as to the creation of a capital item in the hands of the grantee arising from the grant itself. So to break that last point down a little, when paragraph 13.4, or if paragraph 13.4 is applied to the acquisition costs arising from the grant, it does produce circularity. the existence of that circularity in my submission means that a grantor cannot ever have a subjective expectation or intention that the acquisition costs will result in a capital item in the hands of the relevant transferee. And that approach is consistent with the avoidance purposes or the anti-avoidance purposes of the provisions. So those are the headlines. What I want to turn by way of further development then is to the second chapter of my submissions, which deals with the construction contended for by the appellant taxpayer. So the starting point is, by way of reminder, to look at paragraph 12 of Schedule 10, which is
I'm going to say something more about your construction.
I'm going to address the appellant's construction first to explain why it's wrong, and then I'm in the third chapter going to address my own construction. So my aim is to knock down the construction contended for by the appellant and then give to the court what in my submission is the correct construction. So paragraph 12 at page 433, subparagraph 1, a supply is not, as a result of an option to tax, a taxable supply if the grant giving rise to the supply was made by a person who was a developer of land and the exempt land test is met. So we see that paragraph 12 postulates two tests which will disapply the option to tax. The first of them is the developer of land test, with which the present appeal is immediately concerned, which relates to paragraph 13. The developer of land test in paragraph 13 concentrates on two things. One, the person who is making the grant in respect of the land, and two, the consequences of the grant. That is to say, whether there will be, or whether the grantor expected or intended that there would be VAT-bearing capital expenditure. For completeness and for context, the exempt land test, which is addressed in paragraphs 15 to 16 of Schedule 10, concentrates on three things. First, the person who is in occupation of the land. Secondly, their connection to the developer of the land. And thirdly, the purpose for which that person is occupying the land. Now, these two tests are a reflection, as indicated earlier, of the circumstances or the factors which are known to be associated with avoidance schemes in this particular area. And two of the cases that are in the bundle of authorities, Robert Gordon's College, which is at tab 14, and the leading case, Newnham College, tab 16 and tab 25, in the House of Lords and Court of Appeal respectively, give examples of the factors or features which are present in such schemes. And there's a common thread that can be seen to arise from such cases. They generally involve a structure where an exempt taxpayer seeks to interpose a lease or a licence in respect of which the option to tax has been exercised. In order to create taxable supplies against which input tax incurred for the benefit of the exempt business can be recovered. So these types of examples that one sees in the case law inform the type of situation that the legislation is designed to combat. The interposition of a lease, for example, might be characterised as a fragmentation. What I mean by that is this: a fragmentation arising from the supply, where the party who didn't make the original grant makes a subsequent supply under the grant. I'll give the court an example of what I mean by that. An obvious example is where an owner of property grants a lease of the property and then sells the property with the lease remaining in place. So the new owner continues to make supplies under the lease, but he didn't make the grant of the lease. So in doing so, the new owner is making a supply under a grant made by the previous owner. So the court has the reference to combat that type of interposition. Paragraph 12, subparagraph 6, on page 433, specifically addresses the situation where a supply is made by a person other than the person who made the grant giving rise to it. And in short, treats the person making the supply as the person who made the grant, and it requires the anti-avoidance provisions to be reapplied to the supplies so made. So that these provisions, and paragraph 12.6 in particular, operate so as to prevent the anti-avoidance provisions from being circumvented by virtue of a lease being granted by an unconnected party prior to the property being sold. Now, to develop the argument which I am addressing just now, that the appellant's construction of paragraph 13.4 is unsound, the court will recall that the argument for the appellant is that on a proper construction of the provisions, and this is from paragraph 7.10 of the taxpayer's case at page 68 of the core bundle. The appellant argues that on a proper construction, the intentions or expectations of the seller of a property fall to be considered for the purposes of paragraph 13 before the effect of the anti-avoidance rules is taken into account. On that basis, he goes on to argue, and a reference in this respect would be paragraph 1.2 of his case at page 55. He goes on to argue that the developer of land test should be understood as requiring the bringing into account of some, but only limited, deemed knowledge of the law in relation to value-added tax on the part of the grantor. So what the appellant says at paragraph 1.2 is the appellant's understanding of the law, which needs to be brought into account, is only the normal application of VAT legislation generally to the transaction in question, not the complexities of paragraph 12 and following. Now, to some extent, there is common ground between the appellant and the commissioners in that respect, because in my submission, the true position regarding the proper interpretation of paragraph 13.4 is that it does not depend upon knowledge of the intricacies of VAT law as to what constitutes a capital item, and to that limited extent, in my submission, the appellant is correct. Rather, where paragraph 13.4 applies, I want to be careful to emphasise where it applies, because as the court will have detected from the Commissioner's case, my submission is It cannot apply in respect of the acquisition costs arising from the grant, which I'll come on to. So where it applies, its application depends upon the existence of a subjective intention or expectation on the part of the grantor that there will be a capital item in the hands of the relevant transferee. That is to say, put short, a subjective intention or expectation as to the coming into existence of a state of objective fact. Now, to the extent that this issue has been discussed in decided cases, as was recognised by my learned friend, the main case that deals with this so far is PGPH in the first tier tribunal, a judgment of Judge Falk, as she then was, now as I understand it, a judge of the Court of Appeal of England and Wales. And I would want to take the court to what Judge Falk had to say about this particular issue, and that's to be found at page 1060 of the bundle, paragraph 116 of the report. So, commenting upon paragraph 13, subparagraphs 2 and 4, it is clear that references to intention or expectation in paragraphs 13, 2 and 4 of Schedule 10 impose a subjective test. For the test to be satisfied, the relevant person, read short, must have had an intention or expectation at the date of the grant. The question is exactly what that intention or expectation must be. In my view, it must be an intention or expectation to incur expenditure on something which, if it is incurred, will result in there being a capital item within paragraph 113 of the VAT regulations. And that particular case was concerned with building works. And in that particular case, Judge Falk said she considered it must be an intention or expectation to incur capital expenditure with a value of at least £250,000. Now, if one moves on to page 1062 of the bundle, paragraph 120, the court will see a submission by counsel that the references to would become a capital item in paragraph 13.4 and an asset falling to be treated as a capital item for the purposes of the relevant regulations in paragraph 13.8 required the grantor to have at least some understanding of the capital goods scheme. I do not agree. In my view, the question is what PGPH factually intended or expected to spend money on, and whether that expenditure was intended or expected to have a value of at least £250,000, and not what it intended the legal characterisation of that expenditure, or indeed the accounting treatment of that expenditure, if that is relevant to be. The discussion about the argument.
With the capital goods scheme, if you were a trader who only did taxable supplies or only did exempt supplies, would the capital goods scheme affect you in any way?
Well, in the case of the actual purpose of the capital goods scheme, as was discussed earlier, my lady, is to ensure a precise deduction of inputs is made, where a durable item in the form of a capital good with a long life may be used either for wholly taxable or wholly exempt, or some split between the two, and that might change over the passage of time. That's the purpose of the capital goods scheme.
And if you buy an asset of a durable nature, and you're a taxable trader, do you then deduct all that input tax as soon as you buy it?
Yes. And so in the case of a wholly taxable...
If that's more than you're actually earning at the beginning of your business, you can carry forward the deduction further VAT periods?
Yes, it would give rise to a VAT credit, and if that results in a net sum due to the taxpayer, so be it. So in the case of a taxable trader, then the whole deduction is made straight away, because that's in accordance with the basic rule regarding deduction of inputs. And the purpose of the capital goods schemes in that type of trader situation is to ensure that if there are any changes in the nature of the trader's business through the 10-year period, that that's reflected. And in that case, if the whole deduction has been made, the change might be to give back some money to the commissioners if the taxable use doesn't continue for the whole period. In the case of an exempt trader, there might be no deduction at the start, but if the exempt trader begins carrying out taxable supplies using the property on which the inputs were incurred, there may be a claim back for input tax at a later stage. So there is some further discussion in PGPH on page 1062 of this submission that was being made that the reference to a capital item imported or required some knowledge of the scheme, the capital goods scheme on the part of the grantor, and that argument was rejected in my submission correctly by Judge Falk, who held that in that particular case, which was concerned with works in relation to development, improvements being carried out to the property, she held that what was required was knowledge or an intention or expectation of the actual incurring of those costs, to which one would then apply the scheme. And I say that that is correct, that that's what paragraph 13.4 is about. It's about the existence of a subjective intention or expectation about a particular state of facts, to which the law would then be applied. And one can immediately, in my submission, contrast that with the question that the taxpayer seeks to put forward in his written case, which is a suggestion that what paragraph 13.4 requires is the taxpayer to ask himself the question, is there going to be VAT due in this transaction? That's not the right way of looking at paragraph 13.4 at all. Paragraph 13.4 is concerned with a subjective intention or expectation as to the coming into being of an objective state of fact. Now,
I mean, if your definition is right, which you seek to derive from Judge Falk's analysis, in a case where possibly the refinements didn't matter so much, but maybe they did.
yes.
It's an odd way to express it, to say if the grantor intended or expected that the land or a building would become a capital item in relation to the grantor or relevant transferee. I mean, you're saying it doesn't. That's not the intention at all. You've just got to have an intention or expectation about the underlying facts which would have that legal consequence.
Yes, but and I think there was some discussion earlier about why is the provision couched in language that's talking about intentions or expectations at all, instead of simply the existence of a state of fact. And in my
I can see in a case where there is expected to be expenditure, which is expected to be over 250,000, and turns out to be less. I can see why expectation or intention has a role to play there.
My answer, however, to the use of that type of language is to say that that's redolent of the fact that we're dealing here with provisions that are intended to combat avoidance schemes, and the focus is upon the intentions or expectations of the grantor. So it's in this type of situation where avoidance is what the concern is. The grantor will have an intention or expectation about what's going to happen so far as the grantee is concerned. But there's an exempt occupier of the property. That's the avoidance context, as it were. And that is also an answer, in my submission, I should say, to some of the arguments advanced by the taxpayer in his case, where he says, why does it make any difference if the grantor has any knowledge of whether there's going to be capital expenditure, or capital item rather. Why does it make any difference, he says? Well, the reason it makes a difference is, first, that's expressly what the legislation is addressing itself to, is the intention or expectation on the part of the grantor. And secondly, the reason it's addressing itself to the intention or expectations of the grantor is because of the avoidance context. So
can I just check then, is the effect of adoption of Judge Falk's interpretation, looking at paragraph 13.4, to read the words "would become a capital item" as would become something which satisfies the definition of a capital item?
in substance,
Okay.
and I should make clear, as I think I remarked, I'm going to come on to explain why I laid emphasis on this. My argument on behalf of the Commissioners, of course, is that paragraph 13.4 cannot be applied to the acquisition costs of the land. So when I discuss what I say is meant by the requisite intention or expectation, we are necessarily looking in my submission at costs arising otherwise than from the grant in the form of, for example, subsequent development, which is why, as it happens, to pick up on something that was discussed earlier this morning, should any weight be attached to the use of the word developer, my submission is one should attach some weight to the use of the word developer, because we're not talking about the acquisition costs in my submission, we're talking about costs that will be reflective of...
Well, you are talking about acquisition costs, aren't you? Oh no, you say you're never talking about acquisition costs because of the circularity problem.
Correct.
Is that right? Yes.
And the way I seek to address that, and I'll come to this when I positively advance my own construction of paragraph 13.4, is not to say that one should just disregard the references to acquisition costs in respect of land, but rather to say, is it possible to conceive of the existence of a subjective intention on the part of the grantor as to the creation of a capital item in respect of the acquisition costs? And I say it's not possible to conceive of such an intention being possessed.
Because it's up to him whether he adds VAT or not, or...
Because it just takes one straight into the feedback loop, the circularity that's created by applying one's mind to the idea of, can there be an intention or expectation that there will be a capital item in the form of acquisition costs?
As I understand, in effect, you're saying the drafter cannot have intended this circularity conundrum, so one needs to arrive at an interpretation that avoids that. You say the best interpretation to avoid that is to leave out of account the acquisition costs.
Correct. And I say that, to put it shortly, why do I say that's the best solution? Well, it more closely accords with respecting the need for some kind of subjective intention or expectation, because broadly put, the construction for the taxpayer doesn't seem to involve any subjective intention or expectation. It simply involves an application of the anti-avoidance provisions to every sale of exempt land over £250,000. You deem, the way he puts it, the way it was put before the first tier and upper tier, and I think largely before this court, is to say you just assume that there was an intention or expectation that these costs would be incurred as soon as facts A, B and C are established. So it more closely respects the language of the provision, the construction for which I'm contending, and secondly, it more closely accords with the statutory purpose, which is that we should only be disapplying the option to tax in cases where there is some risk of avoidance.
Some?
Risk of avoidance. breaching the principle that an exempt business shouldn't be allowed to recover its inputs. That's why the option to tax is being disapplied pursuant to these provisions. Whereas as construed by the taxpayer, the option to tax is disapplied across the board in arm's length sales of opted land that's exempt. It just creates, as we put it in our case, it creates an anomalous relief that this particular taxpayer is able to sell the property for a price and keep the entirety of the price without having to account for VAT on it. That's an anomalous relief that doesn't serve the purpose of the provisions. So, I had identified for the court the particular formulation of the proper construction of the provision for which the taxpayer contends with reference to those paragraphs in his case. And he says, in his case, as I've mentioned already, that means that in every case of the sale of opted land over £250,000, this applies, and that it's not necessary to prove any more. And I just want to give the court a marker, as it were, at this stage, that even if he's correct in everything else he says, one would still have to have regard to the requirements of the creation of a capital item, which the court saw earlier, which would be use in the business otherwise than for sale. And that's not addressed in the evidence in this case. I'll come to that in the final chapter of my submission. So even if he's right about his construction, there's still a want of findings in fact.
But you still have to do this in two stages. This is your first stage, that the subjective intention is nothing to do with your knowledge or ignorance of VAT law. It's just, as Judge Falk said, as my lord said, that the building blocks of the definition are in fact all in place, whether or not you know that means that it's a capital item.
Yes.
But you then do have to make the second step, which is that you have to ignore the acquisition costs.
I won't put it quite in the terms of ignoring the acquisition costs.
However you would put
Yes.
it. But your point is that by doing that two-stage process, you do at least give some meaning to the intention and expectation
Yes.
element of the test, which you say the appellant's interpretation doesn't.
So, the way I would maybe seek to put it, my lady, at this stage is, on any view, paragraph 13.4 will apply where the capital item costs that one is talking about are to do with construction and refurbishment and those sorts of things. So it's easier to test the meaning of paragraph 13.4 in that type of case, and indeed part of my whole submission is that's the only type of case it should be applying to. And the reason there are such difficulties in applying it in the context of acquisition costs is that you just can't have the intention or expectation in relation to the acquisition costs. So looking at the paradigm of refurbishment or construction costs, I say Judge Falk is correct to have concluded that the intention or expectation is not about the application of the law or an understanding of the VAT scheme. It's simply an intention or expectation that there will be expenditure at least of £250,000 on those type of matters, refurbishment, construction and so on. And it's the grantor that has to have that intention or expectation.
And can I be clear, is there any case on your construction of acquisition of land as opposed to buildings on land and so on, where the option to pay tax will be effective? Or is that option always, on your interpretation, disapplied? under paragraphs 12 and following.
And second. So we're concerned here with the question of whether the option to tax is disapplied by the anti-avoidance provisions.
Yeah.
And in that particular case, my submission is that in the respect of the acquisition costs, one could not use those acquisition costs to disapply the option to tax.
It's never disapplied.
Because you cannot possess the intention or expectation.
And that means that although 4A says the land, or it doesn't have any dispositive effect.
But not because I'm inviting the court to ignore those words or anything
No,
like
you
that.
can look at them as hard as you like until you're blue in the face, but you'll never come up with a case where it does the trick.
That's it.
It's a supposed enabling condition, but one which will never work.
Indeed. And again, put short, what one sees from the structure of these statutory provisions, as was discussed this morning, is that the capital goods scheme set forth in the 1995 regulations is there for a particular purpose to do with ensuring the precision of the deduction of inputs in respect of capital items. And what has been done in Schedule 10 is that provision has been borrowed and just used in Schedule 10 in the anti-avoidance provisions. And in a sense, in my submission, that is perhaps inevitably going to give rise to some issues of construction. And really what one has to do in my submission is recognise that wholesale incorporation of the capital goods scheme for this purpose means that in the context of acquisition costs, one just can't have the intention or expectation. And to take me back to where I think I was in the submission about the construction for which the appellant is contending, his construction is contrary, as I've indicated in my submission, to the language, but also does not give effect to the purpose of the provisions.
Can you have acquisition costs in relation to land which are not actually the price of the land?
I think we were taken earlier to a definition which said acquisition costs included a variety of other costs.
There might not be more than £250,000, but when you buy land, there are all sorts of costs associated.
Well, there's stamp duty to start with.
Yes, well, the phrase is, it's page 492, Regulation 113, it's expenditure relating to its acquisition.
So what if you've got, I don't know, a surveyor who's surveyed the property and charges VAT on their services? Would the expenditure on the surveyor be expenditure relating to its acquisition? And then if there is a VAT element on the surveyor costs, does that bring it within the definition in Regulation 113.1?
Yes, but the problem with, I think with that, Lord, is that we go back to paragraph 13.4, and although there's a reference across to capital items, 13.4 is the land was expected to become a capital item. So the focus there is upon the subject of the grant itself.
Yes, but what we're then looking at are what are the acquisition costs of that land? And it's a capital item.
Yes. So
Where is it? In relation to which the owner incurs VAT bearing capital expenditure being acquisition costs. I'm just sort of, I'm not.
Or in my example, do you say that the cost on the expenditure is not itself capital expenditure?
Well, it's not the land becoming a capital item, which is what paragraph 13.4 is concerned with.
I can't put my finger on it just at the moment, but I did see this morning a definition of the term acquisition costs.
Well, we'll seek to turn that up, Lord, but I think my submission about this is, yes, there is the cross-reference to and the importation of the capital goods scheme in that respect, and we've seen what Regulation 113 says about acquisition costs relating to the acquisition.
It would have to be a cost bearing VAT to fall within paragraph
Yes.
113.1.
Yes. And it has to be above £250,000.
Yes, I'm just struggling to think what that might be.
Well, my submission is that when we look at paragraph 13.4, it's the land is expected to become a capital item. And reading this, I rather suspect this may be an example of the need to construe the incorporation of the capital goods scheme mutatis mutandis, as it were, and recognising that it's now been taken into a very different context, and the different context is...
Say the purchase price was 240,000 and you spent 20,000 on meeting a VAT invoice from your surveyor, so as to take it over 250. That would qualify, wouldn't it, even though you only got over your 250 floor by including a little bit of associated cost? I mean, assuming for the moment that the 240 was vatable, I'm just trying to see what expenditure relating to its acquisition means. It's quite a broad term.
Yeah. And the focus, of course, is... So I've made the point that I mentioned a moment ago about 13.4 is about the land, but there is also the requirement that the grantor intends or expects that these costs will be incurred. And the focus of the types of issues that are being raised with me at the moment in my submission are upon costs that might not be within the intention or expectation of the grantor as such. They might be costs that the grantee is going to incur. But whether the grantor intends or expects them to incur them is a rather different matter. But it would, again, if we're talking about a subjective intention or expectation, that would plainly necessitate proof of that intention or expectation on the part of the grantor.
But I mean, just taking Lord Briggs's example, I mean, what do you say about that? Would that fall within this regime or not? Suppose that the grantor does have subjective knowledge that the grantee has spent, what was it, the 10,000 on the surveyor. How does one work through the operation of the regime in that situation?
So I think my submission, Lord, is that which I've outlined already, that even assuming the requisite subjective intention or expectation, 13.4 is focused upon the land itself. And although in the different context imported for these purposes into the anti-avoidance provisions, but in the different context of the capital goods scheme, there is a reference to relating to the acquisition. For the purposes of paragraph 13.4, the focus is on the land becoming the capital item. And in my submission, construed in that context, the reference must be to the cost of the land itself.
But your point about there being a wholesale incorporation of the definition, which doesn't quite work, the trouble is that 13.4a is not part of the incorporated definition, it's part of the actual provision.
Well, indeed. And I have to recognise to some extent, the force of some of the submissions made by my learned friend about the idea that anti-avoidance provisions of this sort may be cast in language that are intended to reflect the possibility of ingenuity that has not yet been identified. I recognise the force of that, but so far as the specific question which in my submission is raised by this appeal is concerned, can you have a subjective intention or expectation, can the grantor have a subjective intention or expectation that the grant, the costs from his grant, will be a capital item? My submission is you cannot have that intention or expectation because that's the thing that gives rise to the circularity.
And the question that I asked Mr. Simpson, which is in the what one might think of the paradigm example where the grantor sells a plot of bare land to the relevant transferee, knowing that they intend to build a splendid office block on it for £5 million.
Yes.
That, how does that then
So in my submission, that's caught by paragraph 13.4b, and in particular,
be constructed?
To be constructed. So if you have bare land, but you're going to, there's a knowledge of intention or expectation that construction is going to take place, it's caught by that.
And so in those circumstances, it would be a developer.
If there was yes.
And so
the point is those costs are not arising from the grant itself.
Right. And so then the option would be disapplied.
I'm sorry, my lady?
So what would be the effect of...
Well, if the exempt land test and the eligible time tests were all met, then the option would be disapplied. So, in looking at the construction for which the taxpayer in the present appeal contends, one is driven to say this, certainly, in my submission. If paragraph 13.4 operates as he would have it, that if there is a sale of opted exempt land and the price is more than £250,000, the sale is an exempt supply. Paragraph 13.4 is a remarkably indirect way of saying that, with all its references to intention or expectation and the like, if it's really as straightforward as the taxpayer would have it. So I'm about to try and to draw together the criticisms of the taxpayer's construction with reference to 5 specific points. But before doing so, I want to just mention this. The taxpayer in his case at paragraph 7.17 on page 70 of the bundle endorses the approach taken by Lord Docherty in the Inner House at paragraph 54, and paragraph 54 of Lord Docherty's opinion is at pages 166 to 167 of the bundle. And the proposition which Lord Docherty advances and with which the taxpayer agrees is that paragraph 13 as an anti-avoidance provision should be construed so as to have a broader rather than a narrower effect. And the authority upon which the taxpayer relied and which Lord Docherty followed for that was a passage in the speech of Lord Hoffman in Newnham College in the House of Lords at page 641 of the joint bundle. And the particular passage upon which reliance was being placed is on the third line. The latter is an anti-avoidance provision which should be given a wide meaning. That's what Lord Docherty founded upon, and that's what the taxpayer founds on here. Just to be clear, paragraph 15 is Lord Hoffman reciting the submission for the commissioners in that case, which at paragraph 16 his lordship rejected. So the broad submission that these are anti-avoidance provisions, so they should be broadly construed, was rejected by Lord Hoffman, far from being endorsed. The principles which should inform the proper construction of these provisions are set out in the Commissioner's case, and as was said by my learned friend, I don't think there's much between the parties as to what the applicable principles are. So I wanted to turn to the five criticisms, principal criticisms I would make of the appellant's construction. The first is this, that the appellant appears to recognise that a grantor, considering the provisions in paragraph 13, contain an inherent circularity which, when applied to the acquisition costs themselves, will create this feedback loop or circularity. To get round that, the appellant contends that one should just proceed on the unusual and unprincipled basis that the expectation or intention should be tested on the assumption that the anti-avoidance provisions do not apply. And in my submission, there's no sound basis for that proposition.
I think he puts it in a time way, doesn't he? He says have yet to apply, because you test it just before they do apply.
Yes. But I say that that's an unprincipled and an unsound approach to take when one looks at what paragraph 13.4 actually says. The second point is that the appellant's approach, which seems to involve the attribution of a deemed or imputed intention on the part of the grantor, based on the fact that it has opted to tax the property, in my submission is a tacit acceptance that the grantor cannot hold an actual intention in relation to that matter. He instead proceeds on the basis of the deemed or imputed intention. The third criticism of that construction is it removes all content in my submission from the requirement that there be an expectation or intention that there will be a capital item in the hands of the relevant transferee.
Could that be remedied by applying Judge Falk's approach, by saying, well, it's not actually the outcome, the legal outcome you're looking at, but just the underlying facts?
Judge Falk, in my submission correctly, however, still proceeded on the basis that there had to be an actual intention or expectation as to a state of facts, rather than a deemed intention.
But if you're operating on the principle of working out what would the position have been in but for the anti-avoidance provision,
yes,
you can still look at objective facts, and then the lawyers come along and apply the construct of what that outcome would have been but for the avoidance provision.
That I think is the argument for the taxpayer, that that's what one should do.
But that wouldn't be a deemed intention. That would be an actual intention or expectation about the underlying facts. It's just that the legal consequence would be in a parallel universe.
These may amount to much the same thing in my submission.
But you wouldn't ever need to get there, though, unless, well, when it refers to land, is that bare land without a building on it?
Yes.
And the building is always the building plus the land, presumably?
Yes.
But assuming that in the paradigm case where you sell a building to someone and you know that they're going to refurbish it, then the intention and expectation will be that they're going to refurbish it, but you don't really need to rely on that, provided that the cost of the land is more than 250,000 on the appellants.
Correct, indeed. Because on their construction it becomes a capital item just because of the acquisition costs.
Incidentally, I should say I found the definition that I had in mind, but it's not relevant to section 13. There's a definition of acquisition in section 14 in relation to development financiers.
Yes, my apologies.
So we can forget about that.
So, I think what I've been saying is that the third criticism is that I say that the appellant's construction removes all content from the requirement that there be a subjective intention or expectation, and instead creates this deemed intention that there will be a capital item in transactions of this sort. But that construction is not consistent with the statutory purpose. It's not achieving the statutory purpose, it's giving rise to an anomalous relief. And fifthly and finally, in relation to this, my submission is that where the court is faced with competing interpretations, one of which in my submission doesn't involve an subjective intention or expectation, and which does not further the statutory purpose of these provisions, on the one hand, and a construction of the provisions that does respect the existence of a subjective intention, and which does further statutory purpose, the court should prefer the construction for the commissioners, and that's the chapter to which I now turn. So I've submitted already that in my submission, paragraph 13.4, properly construed purposefully, was not intended to apply to this transaction viewed realistically. In particular, properly construed paragraph 13.4 does not disapply the option to tax on a grant of land because the acquisition costs in and of themselves do not and cannot create the requisite subjective intention or expectation. So
I think I understand your submission to be that your construction doesn't lead to this disregard or this trigger being pulled in ordinary arm's length bona fide transactions, whereas theirs does. And it's your point about their construction not being consistent with the anti-avoidance purpose. At the moment I've not quite understood why yours is any better than theirs in that context.
Because in my submission, the basic or default position should be that if land has been opted, then supplies made in respect of that land should be taxable. That's the default position created by the exercise of the option to tax. And one should only, in my submission, purposefully be disapplying the option to tax where the risk that these provisions are intended to counter is present. The exempt business trying to recover input tax, and nobody is suggesting, neither party to the appeal is suggesting that there's any avoidance risk in a transaction of this sort.
So the option to tax has benefits and burdens, and the taxpayer has to work out which is going to be more valuable. But once they've exercised the option to tax, then you say they're stuck with it unless these provisions apply. And
Correct.
this,
But
their construction would allow people to take the benefits but not have the burdens of the option to tax in a much wider
It certainly
series of
has that risk.
situations.
Yes.
But I understand that. But in a case which on your construction would trigger the disapplication of the option under 13(4)(b, because there was an expectation that the buyer was going to spend more than $250,000 on improvements, why is that any better reason for, as it were, writing off the consequences of the exercise of the option by the seller?
To put it very shortly, because that's the type of situation where avoidance occurs. It's that type of situation where a scheme has been constructed whereby the focus is upon an exempt person in occupation that makes the land exempt, or makes it eligible, rather, makes it exempt. And it's the intention or expectation that the transferee is going to incur that expenditure that is going to benefit the exempt business.
And all too often there'll be connected persons, as in Newnham and
Correct.
Yes.
Robert Gordon.
Correct. So I think I said earlier, and I'm keen to avoid trying to take the court's time up with detailed discussions of how avoidance schemes arise, because there are myriad circumstances, but that is the type of situation where avoidance occurs. That's what these provisions are directed to, and it's common ground between the parties that the purpose of the provisions is to stop exempt businesses recovering inputs. So, looking at the construction for which I contend, we are concerned in particular with the developer of land test in paragraph 13, and I do submit that the use of that phrase, I touched upon this earlier, the use of that phrase is, in my submission, at least consistent with the idea that something is being created or done, or that something has recently been created or done, and that's why the word developer is used, albeit it's then the subject of a detailed definition. And in the case which I say paragraph 13(4) is actually concerned with, where works are to be done to land or a building that's on land, that there's an intention or expectation that these works will be done, it should be possible to identify and evidence the existence of that subjective intention in the sort of way that was done in PGPH, by looking at the various materials that there were that showed the existence of the requisite intention or expectation. But the same cannot be said in relation to the acquisition costs associated with the grant itself.
When I put that point to Mr. Simpson, he said, well, the term, that if this had been within the eligible time as far as the appellant is concerned, then there would be no doubt that it fell within 13(2) as a grant made by, or they would be making the grant as a developer of the land, because the land was a relevant capital item for them and was made as at a capital time, made at an eligible time.
Yes.
For them, so it would work even though they couldn't possibly be described as a developer of the land. So he relied on that as saying you can't assume that there has to be some kind of development going on. So do you have...
And I recognise that,
Yeah.
that's why I don't seek to take the point about the use of the word developer too far,
Right.
but I do suggest that it is of some assistance. But I certainly recognise that in the case of, in the situation where the land is a capital item in relation to the grantor, and the grant is made at an eligible time, one wouldn't ordinarily describe that grantor as a developer, and I recognise that. But for the reasons I've been discussing, and as fully set out in the Commissioner's case, if one is focused upon an intention or expectation which is of a subjective nature, one cannot have that in respect of the capital item created by the grant, because if you could, you would be in the feedback loop, you would be in the circularity that creates. So there are a number of specific criticisms made of the Commissioner's construction by the taxpayer. Three main criticisms, I think, and I'll seek to address those. The first is, it is said the Commissioner's approach is incompatible with the words of the legislation, or that it requires the reading in of words to the legislation. That point's made at paragraph 7.24 of the taxpayer's case. Secondly, it's said that the Commissioner's construction gives rise to redundancy. Some words in paragraph 13, 3 and 4 cannot have an application, the taxpayer says. And thirdly, the Commissioner's approach is said, with no apparent irony intended by the taxpayer, to give rise to capricious results. So, looking at each of those in turn, my submission is that the Commissioner's construction is not incompatible with the words of the legislation. It simply involves considering the question of what a grantor intended or expected in a different, and I say correct, manner to that proposed by the appellant. To put that matter more fully, the Commissioner's construction involves recognising that as a result of the terms in which the provisions are drafted, but which I say reflect the underlying purpose of these provisions, a taxpayer cannot have an intention or expectation from the mere fact of the grant alone that acquisition costs will result in a capital item in the hands of the transferee.
Your voice is dropping again, Mr. Thompson.
My apologies.
Can I ask you, how on your argument can 13.4 ever apply to land?
Well, we say that one cannot have the intention or expectation in relation to the acquisition costs, and in that respect, it cannot apply to the acquisition costs in respect of the land. That's undoubtedly the effect of the construction.
And acquisition cost is the only competitor on the block under the regulations.
Correct.
So, so how do you get round that?
Well, I seek to get round it by saying that what Parliament has done is incorporate the capital goods scheme without modification, which gives rise to the potential for issues of construction, and that has happened in my submission. But one then looks at the question of whether you can have subjectively an intention or expectation that the acquisition costs will create a capital item in the hands of the transferee. For all the reasons I've been touching upon, one cannot have that intention or expectation. So I'm not disregarding words in the statute, but saying that, at least as matters stand, there is an inevitable answer to the application of the statutory words in a case of this sort. And the inevitable answer is that a grantor cannot have the requisite subjective intention. But that's not...
The incorporation of the capital goods scheme is sort of goes further than just the express cross-reference in 13.8. It sort of infects the whole of the drafting of Regulation 13. And if one was being uncharitable, one would just say they haven't really thought it through. If one was being more charitable, one would say it's there as a place marker because one can never foresee the ingenuity of tax avoidance schemes, and it might...
Or maybe both. Or maybe both. But for my purposes, the critical point is, my submission is, I'm not inviting the court to disregard or rewrite paragraph 13.4, but rather saying that the application of it in relation to the acquisition costs of land means that the answer is going to have to be, you cannot have that subjective intention or expectation.
So, have I understood it correct? And you say it's an inevitable answer as matters stand. Is the answer you're giving to my Lord's question that paragraph 13.8 says capital item has the meaning in the relevant regulations? Those regulations could be changed.
Yes.
You say paragraph 13.4 has, if you like, the meaning that one gives it as the primary legislation, which imposes certain restraints on what can be brought into account in terms of assessing the intention or expectation. We've got a cross-reference to a set of regulations which, when one reads those across in the light of the dominant scheme in paragraph 13.4, means the answer in relation to land is always that there is, sorry, I'm losing disapplication. But it's conceivable that the regulations could be changed to, in some way, that would make it applicable in relation to land in future. Is that what you're saying?
That's what I had in mind when I said as matters presently stand, yes. But
so is your attempt to avoid, if you like, the redundancy of paragraph 13.4a, that while it's in fact practically redundant at the moment, that's a consequence of the drafting of the regulations. That might change, and it is conceivable that in other circumstances it wouldn't be redundant.
correct.
That's the way it works. All right.
Correct. But the headline for my submission is apply the test, but I accept that on my analysis of the provisions, the application of that test in this particular case must have a particular result, which is that you cannot possess that subjective intention.
Is that because giving effect to the regulations currently in force would be inconsistent with the purpose of primary legislation? Is that really what it comes to?
No, that's part of the context that informs the construction for which I contend. The reason one cannot possess, the grantor cannot possess subjectively the intention or expectation that the acquisition costs will create a capital item is that creates the circularity about whether there's to be VAT on the acquisition costs or not.
Yeah.
Well, perhaps a better way of expressing it, yes, they do have an intention or expectation, but it's not a relevant one for the purposes of 13.4. Their intention or expectation has to be about something other than just the acquisition costs.
Indeed, and in the case of land, one can apply sensibly and consistently with the statutory purpose, one can apply that to things like redevelopment costs and so on, but not costs arising from the grant itself.
I mean, the trouble I'm having with it at the moment is it looks to me as though we're having to rely on what are really, I mean, we have the words of the statute, which are plain enough, and the words of the regulations which are incorporated into the statute, and you're relying on other considerations to effectively disapply the words of the legislation itself.
So the way I would seek to address that, my lord, is that although it is said against me by the taxpayer that the Commissioner's construction involves ignoring that the definition of capital items in respect of land is acquisition costs. They say I'm ignoring that, and I say I'm not ignoring that. I'm focusing on the actual wording of paragraph 13.4, which says, does the grantor intend or expect? And I say you can't have that intention or expectation. So rather than disregarding the provisions, I'm applying them, is what I would say.
Yeah, and you can't have it because it leads to the feedback loop, as you call it.
Correct. And that, to that extent, as I said a short time ago, the taxpayer seems to recognise that by saying, let's have this deemed or imputed intention in every case where it's a sale of opted exempt land over £250,000. Let's say that that means the grantor intends or expects that there will be a capital item, even though, of course, in reality, there won't be a capital item because he's not charging VAT on the item in question.
I mean, in a certain sense, you want a deemed intention as well, because you say leave out of account certain things which might subjectively be in the mind of the grantor, but you say they're not factors which can legitimately be brought into account because of the operation of the statute. As I understand it, you are saying, well, be that as it may, my partially deemed intent is closer to what the statute appears to require than the constructed intent that the other side seek to create.
So I certainly say the latter point, that the construction for which the Commissioners contend better achieves the purpose of the provisions. I would perhaps quibble with the suggestion that it's a deemed intention. Rather, the point here is, in my submission, you just can't have the intention. It's not possible to have that subjective intention. And there is some discussion, I should say, it's referred to in the written cases. In PGPH and Shergard, there is some discussion. Shergard is one of the other tribunal cases about this. There is some discussion about would it be enough, for example, for the taxpayer genuinely to think that a capital item was going to arise because he'd received advice to that effect, but it turns out that advice was wrong, and the tribunals in my submission correctly identify that that's not what the intention is about.
Because Judge Falk is saying it's not the legal outcome which you have to have an expectation about, it's the facts, which may be future contingent facts which haven't happened yet, like improvements,
Yeah.
which, if they happen, would justify that outcome.
Indeed.
But you can't include in that basket of possible facts the question of whether VAT is going to be charged on the acquisition costs or not, because then you get into the circularity problem. So whatever their intention or expectation is about charging VAT or not charging VAT on the acquisition costs, that's not part of the intention or expectation which is being referred to in paragraph 13.4.
And as I've submitted, the difficulty arises and can be seen to arise only in the case of the attempt to apply paragraph 13.4 to the capital item arising from the grant itself. As soon as we're not looking at the grant itself and we're talking about redevelopment costs and so on, it becomes quite a straightforward exercise to say, does the grantor intend or expect that will happen? But one is in the parallel universe, or call it what one may, of trying to work out how the grantor can have such an intention or expectation about the very transaction which is or is not to bear VAT.
And did you say, is it Shergard that was the case about what if you were wrongly advised that it was going to be a capital?
Yes, so that's at tab 34 in the authorities, and
You have an electronic page that you could...
so it begins at page 983, and the...
Did you say 983?
yes. And the paragraphs I had in mind are at page 1012, beginning at paragraph 93, there's a heading, the subjective test. And at the end of paragraph 95, the court will see 3 lines from the end. Counsel argued that the words intended or expected indicated that one must look at all genuine subjective intentions and expectations, and not only those which are based on a correct view of the law. In our opinion, such a submission is tantamount to asserting that because a person desires their intended actions to have a particular legal consequence, they are to be construed as having that consequence, no matter what their actual effect in law. This is to usurp the function of the courts, and so on. So, in responding to the particular criticisms made of the Commissioner's case, I've been dealing with the first proposition that it's incompatible with the words of the legislation, and as I've indicated, my submission is that that's not correct, and that the appellant himself, I say, seems to recognise that by, I say, talking about a deemed or imputed intention, and it's also reflected, I submit, in relation to the absence of direct evidence being led by the appellant taxpayer as to what his intentions or expectations were at the time of the grant. So far as this idea of a deemed or imputed intention is concerned, if I could just give the court these references, that paragraphs 22 and 23 of the appellant's skeleton argument before the first hear are at pages 205 to 206. So 22 and 23 at page 205 to 206, and similarly before the upper tier, paragraphs 37 and 38 at page 130. These make it clear that the taxpayer was saying, and I think still is saying, that the intention is a deemed or imputed one.
Sorry, that?
Is a deemed or imputed one,
Yep.
sorry, Lord. So, I submit that the real difference between the parties is not that the commissioners are seeking to read words into the legislation or to ignore words, but rather that the commissioners recognise the logical consequence of the grantor not being able to have such a subjective intention, which is that the test cannot be met, and that the appellant instead seeks to avoid that conclusion by arguing for a deemed or assumed intention. And I say it's the use of that assumed or deemed intention that's contrary to the provisions in question. So far as the second criticism is concerned, I would simply give the court the reference to paragraph 85 of the Commissioner's written case at pages 109 to 110, where we deal with the arguments based on redundancy. And the third and final criticism is that the Commissioner's construction is said to give rise to capricious results. The principal focus of the argument for the taxpayer in that respect appears to be to ask a series of rhetorical questions about why it matters if the grantor has any knowledge about what is to take place. And the short answer to that is, it's not just knowledge of the grantor that is relevant here, it's the intentions or expectations of the grantor. That's what paragraph 13.4 specifically addresses itself to, and I've submitted to the court already why that is so.
Did you accept that none of the tribunals below accepted your interpretation?
I think I would have to accept that the construction contended for by the commissioners was not accepted by the tribunals below. At least tacitly not accepted by them. They didn't say in terms, but the exercise on which they embarked indicates that that is so, and it certainly wasn't accepted by Lord Docherty in the Inner House.
But you're not seeking, you don't seem to be seeking to rely in the alternative on any of the bases on which they did find in favour of UKSC, or are you?
Well, there is certainly some difficulty one would have to accept in analysing certain parts of the first tier tribunal's judgment as to what constitute findings in fact and what don't. But by the time the case reached the upper tribunal accepted the submission for the commissioners that the taxpayer did not have findings in fact to support the existence of any subjective intention or expectation, and the Inner House affirmed that finding of the upper tribunal, and I certainly defend that aspect of the reasoning. And so far as the final chapter of my submissions is concerned, about the absence of findings in fact, this of course is an appeal from the decision of the Inner House. The Inner House took the view that the tribunals could not be faulted for the approach they took to the findings in fact, and I say that the Inner House was correct in that respect. And I'll come to that in just a moment, what the Lord President had to say in that respect.
It might be thought to be slightly curious that leave to appeal was granted on the basis of the decision was the facts, was the state of the evidence.
Yes, the circumstances...
Concurrent findings of fact by at least both the courts below, if not all three of them.
Certainly, one might say there hasn't been a consistency of approach in the Inner House as to which cases will be given permission to appeal in revenue cases and which won't. But in this case, myself and Mr Simpson were both at the application, and it was indicated quite quickly to us that as a revenue case this should be given permission. Of course, this was a case in which there was a dissenting opinion by Lord Docherty, which doubtless played a part as well. So I think I can turn to the final chapter, which is this question of there being no findings in fact to support the allowance of the appeal, even if the legislation bears the meaning for which the taxpayer contends. Of course, if I'm right about the construction, there cannot be the requisite intention or expectation. If in its purest form the taxpayer is correct in his construction, which is that the intention or expectation is made good merely by the sale of opted land, which is exempt for more than £250,000, then there might not be a need for any more findings in fact than that. But we do say, for example, that there would have to be an intention or expectation, for example, pursuant to Regulation 112 and 113, that it was going to be used in the business of the grantee otherwise than for sale. So there would have to be evidence of that was the intention or expectation of the grantor, and I say that the taxpayer did not adduce any such evidence.
Is that a new point? Is the used in the qualifying manner point a new one? I can't recall where it comes below.
I think it would be fair to say that there hasn't been a focus in the courts below on that specific aspect of the 1995 regulations. The more general point has simply been taken by the commissioners from the upper tribunal that the first tier did not make the findings that the taxpayer needed, and that there was no basis to interfere with its findings. The proper approach to this aspect of the taxpayer's appeal in my submission is to be found in paragraph 16 of the opinion of the Lord President, which is at page 156. It will be seen that the Lord President, in that paragraph, beginning at 4 lines into the paragraph, identifies that the problem for the appellant is that he did not lead any evidence of his subjective intention or subjective expectation or intention in relation to the status of the land as a capital item in the hands of the purchasers.
I'm so sorry, which paragraph are you reading from?
Paragraph 16 on page 156 of the bundle.
Yes, thank you.
This is the opinion of the Lord President. So after saying that, and just to be clear, the Lord President specifically referred to and comments upon Mr. Murdoch's affidavit, which the Lord President says had a passing reference. There was a passing reference in the affidavit to the letter, and the letter was a request for a review. It sets out Mr. Murdoch's understanding of the position and included the short sentence in question. And the short point which the Lord President correctly makes there in my submission is the correspondence to which the court was taken earlier is correspondence written by Mr. Murdoch some years after the grant, in which he simply effectively recites, he says he has reviewed the legislation. The natural reading of the letters is at the time of writing them, and he then repeats the legal test that there was an intention or expectation that the property would become a capital item. It's just a repetition of the legal test, and the Lord President in my submission was correct to treat that evidence in the way that he did. With the
They
result,
presumably knew that Cumbernauld was a business. They knew that the opticians were there occupying under a lease, and the sale was subject to the lease. Isn't that enough to show that they knew that it was going to be leased to them? You pointed us to the fact that the legislation deems or treats it as being a grant by Cumbernauld
Yes.
to the lessee. What else do they need to know, really?
So first of all, it depends upon what the proper interpretation of paragraph 13.4 actually is as to what they need to prove.
Yeah.
But if the court arrives at a construction of paragraph 13.4 that involves any subjective intention or expectation, my submission is, and was before the upper tribunal, that no evidence of that subjective intention on the part of the grantor was led. But even if the court were to take the view, even if the courts below had taken the view that Mr. Murdoch's affidavit and letter read together should be understood as proving all these things, it was really a matter for those courts to reach a view on what they would of that evidence. And in my submission, it's not now for this court, at least absent some clear application of the principles which arise in relation to findings in fact. It's not for this court to be asked to re-evaluate that primary evidence.
Cumbernauld, of course, is a local authority, and one of...
No, I think it was an SPV company.
Yes, I was going to say it's an SPV, but it was a company, but there's no evidence. I'm assuming it's an SPV that belongs to the local authority, but maybe I'm wrong about that.
I don't know either, I have to say that.
There we are. None of us know.
So short submission is that the Inner House was entitled, in the proper application of its appellate jurisdiction, to say that there was a want of findings in fact to support the appeal. So, for all the reasons set out in the written case, and which I've sought to address this afternoon, in this, again, what one fancifully might call a short but difficult point of construction, I invite the court to refuse the appeal and to adhere to the interlocutor of the First Division.
And I think Lord Menzies agrees with, specifically with paragraph 16 as well, isn't he? Paragraph 21. Yeah.
He did. But the Lord President and Lord Mingus gave effect to what I had characterised as the short answer to the appeal, which was, this is all about the absence of findings in fact.
Thank you very much, Mr. Thompson. Mr. Simpson.
Thank you, Lord. Yeah, just a few minutes standing. Response. I start noting that my friend on a number of occasions has said that the appellant's position is that any supply which involves land or buildings that are opted to tax and is taking place at a value of more than or not less than £250,000 has a result that the option is switched off under paragraph 12 and 13. That's not correct. First point, as I've made clear, I hope in my submissions earlier, the appellant would accept that there must also be knowledge of the fact that the transferee is going to use the land or buildings in the course of business otherwise than solely for the purpose of sale. In my submission, what your leadership said a few moments ago is entirely correct, that knowledge of those things is enough. Taken with knowledge of the option, so it's not just the fact of the option, the 250,000, it's knowledge of the option and £250,000 price that are necessary.
If we go to your paragraph 714 at page 35 of the main bundle.
Yes, my Lord. Yes, my Lord. And accept that that paragraph isn't sufficient.
Yeah, it's insufficient.
Yep, that's right.
There's that further element of knowledge the transferee will use the land or buildings in the course of business.
Precisely. Precisely. But on the facts of the present case, as Lady Rules pointed out in my submission, there was, on any view, that knowledge. Second point, my learned friend has characterised the appellant submission as involving some sort of deemed or imputed intention. Now, my submission is that's not the case. The submission is that the intention or expectation, as is the case in so many other areas of law, has to be objectively ascertained. So if, looking at the facts objectively, the appellant must have known, for example, that he had opted to tax, he cannot come to court and say, well, actually, subjectively, I had no idea about options to tax. But that's not deeming him to have had an intention. It's simply ascertaining his intention on an objective basis, which is, as I submitted, a reference to the example of Muirhead and Turnbull against Dixon, what the law normally does. The third respect in which my friend's characterisation of the appellant's case was not correct is that my friend, as I understood him, said that when those elements of intention were met, then the option was turned off even in an arm's length transaction. Again, not the case, because it's necessary also for the exempt land test to be met. And the exempt land test requires one of the risk factors that my friend identified to be present. I suppose two of the risk factors. First, a taxable person occupying premises for the purposes of carrying on an exempt activity. And second, that person being connected to the grantor or a development financier or someone connected with either of them. So in my submission,
Where is the connection test?
that is in the exempt land test. Lady, it is
15.3b.
Yep, paragraph 15.3b, which I think is somewhere around page
439.
Yes, 439. Thank you, Lord. So yes, it's in fact the relevant a relevant person must be an occupation of the land. And
No, I
that is-
meant how do you know who is connected with whom? Is there some imported
yes,
definition
Well, it
borrowed
is-
from somewhere else?
it is the definition from I think the Companies Act 2010. Let me just see if I can. I think it might be the end of 112.
Maybe it's paragraph 3.
That's right, 12. I'm told it's in paragraph 34, that's right, which page it is. The page number for this thing. Yes, it's page 476. I'm sorry, I should have had that at my fingertips. It's section 1122 of the Corporation Tax Act 2010. It's the imported definition in paragraph 34(2) of Schedule 10.
Yes.
So the exempt land test requires occupation for basically carrying on exempt activity by either the grantor or a development financier or someone connected with either of those. In the present case, of course, the Optical Express company was connected with the grantor because Mr. Moulsdale, as I understand it, broadly speaking, owns Optical Express. That led Mother Briggs to ask, on HMRC's case, there's a difference between refurbishment costs which are expected to be incurred and costs of the actual grant. Why should one be sufficient to, or an expectation of one be sufficient to switch off the option, with the expectation of the other not? My friend's answer was that was an avoidance risk. And in response to a further question by my Lord Reid, the chair, the further answer was that the avoidance risk was because the transferee and the occupier are often connected. But the connection between the transferee and the occupier is not relevant. The exempt land test doesn't look at a connection between the transferee and the occupier, but looks to occupation by either the grantor, not the transferee, or someone connected to the grantor, or someone who has financed the grantor, or is connected to someone who has financed the grantor. So it's no answer in my submission to say that there is some difference arising because one might expect the risk to obtain where the transferee and the occupier are connected, because that's not what the legislation is looking at all. It's looking at the risk identified by the legislation is where the grantor is the occupier, or someone connected to the grantor is the occupier, or development financier, as the case may be. So in my submission, in those significant ways, Miller Friend's characterisation of where the appellant submission led was not correct, and therefore, in my submission, the various criticisms Miller Friend made of the appellant submission were unjustified. Ultimately, in my submission, it is a straightforward matter to interpret 13.4 in the way and apply in the way I've decided, in the way I've set out. One looks at knowledge of facts on an objective basis, and if objectively that knowledge exists, then there is an intention for a capital item to be created, and then applies legislation. The legislation says, well, you're not going to create a capital item after all. The intention is thwarted, and there's nothing extraordinary or unacceptable about that. Just as, for example, in the same way, although it's somewhat different, for anti-avoidance provisions say that if you have a main purpose of carrying out a transaction, that purpose is going to be thwarted. Doesn't stop you, it doesn't bring you into a loop whereby suddenly you can't have had that purpose after all. One looks at the facts before the legislation applies, one then applies legislation and doesn't go back on an iterative basis to look at how the facts, what facts are after the legislation has been applied. That's all I want to say, I think, about the statute interpretation point. Briefly, on the facts, of course, another friend points out that the upper tribunals and the inner house's majority decision was that they regarded there as being insufficient findings of fact to allow the appeal to be upheld. Of course, that was on the footing that Mr. Murdoch's witness statement was not in evidence, nor were the letters spoken to by him in that statement.
So, I thought that the inner house accepted that Mr. Murdoch's affidavit was in evidence.
I'm not sure it went that far.
Or at least treated it as evidence.
The Lord President at least called it an affidavit.
Yes.
So it may be that, yes,
And indeed he then goes to analyse it as evidence and says, well, this is in effect expressing Mr. Murdoch's views sometime after the event. It's not giving evidence of the subjective state of mind of the appellant at the relevant time.
Yeah, so maybe at least the Lord President was looking at it as if it were evidence. In any event, of course, Lords and Lady, my submission is that, yes, the Lord President says, or refers to, in effect, a submission on the law, that there was no intention or expectation that the asset would be within the capital goods scheme. My submission, of course, is that the three letters I've referred to, and took your lordships and the lady only to one of them, set out rather more than that. They set out a number of facts. A number of facts which, in my submission, on an objective basis, must have been known to the appellant because he was the person who owned the property, had opted it to tax, and was party to the lease with Optical Express and the sale agreement with Cumbernauld SPV. In any event, in my submission, although not terribly clearly expressed, the first-tier tribunal at paragraph 37 of its decision appears to proceed on the footing that Mr. Moulsdale did have the relevant intention or expectation, and that was why, according to the first-tier tribunal, and considering the legislation, the view was taken that it applied, and therefore the option was switched off. The first-tier tribunal could not have reached that conclusion unless it first was of the view that Mr. Moulsdale had the intention or expectation that would lead to the application of that legislation. So paragraph 37 and 38 at page 192. I therefore renew my motion, unless there can be further assistance, that the appeal should be allowed simpliciter or allowed, but with an order for it to be remitted to the first-tier tribunal. Move on.
Thank you, Mr. Simpson. Well, we're grateful to counsel. You've left us with a nice conundrum. I will take time now to consider it and let you have our judgment in due course.